All right, back live tonight, you're in Focus. The Pretoria High Court has heard the DA's application to have load shedding declared unconstitutional. The official opposition also called for the appointment of a specialist to oversee the implementation of the Energy Action Plan. Newzroom Afrika's Juniour Khumalo was at court and filed this report.
The Democratic Alliance has laid the blame for the high levels of load shedding at the door of the ANC-led government.
It is clear that whatever the President and his cabinet ministers averred, the consequences of policy decisions, and we would include policy decisions as part of this concept of conduct, resulted in the current need by Eskom to continue to implement various levels of load shedding.
In an interesting turn of events, Eskom and the energy regulator, NERSA, also threw the government under the bus, saying there was no doubt that the state was to blame.
First is, we do take issue with the DA when in their prayers they go further and they finger Eskom as one of the parties to blame for the load shedding. And that is the part only that I will address. So in other words, we have no quibble, we are indifferent to the debate about the state's responsibility for load shedding. Eskom was the victim of that conduct. That was the conduct in these words. This was the conduct of senior executives of Eskom involved in the abuse of their position and power and undue influence on subordinates in order unduly to benefit the Guptas.
With most parties placing the blame on the ANC government, the DA argued that the architects of Eskom's demise cannot be entrusted with turning around its fortunes.
So we'll be asking the court to appoint a special master, what in law is called a special master, to oversee, to regulate, to monitor the implementation of that plan.
Although under slightly different circumstances, the DA argued that precedents had been set twice before for a court to appoint special masters.
There's a precedent for this. You'll remember when there was the SASSA grant crisis, another one's coming, but it's the one before that I'm talking about now. The court appointed a special master because they declared that the department was unable to solve that problem.
There have been two cases in South African law where a special master has been appointed, and the government's response and the various other respondents, Eskom's response in this case, is effectively twofold. One is the appointment of a special master generally would be a breach of separation of powers. The Constitutional Court dealt with that argument in those two cases. Of course, separation of powers is a factor that the court will consider before it issues a supervisory interdict.
Eskom's legal team and Judge Joseph Davis raised the issue of separation of powers, asking how the DA envisaged the oversight work by a specialist being conducted. The Utilities Council said in the two prior instances when the court had appointed a special master, there were clear and defined parameters, while in the DA's application, this wasn't the case.
What the court supervised was a narrow, definable task that began and ended. It had a time date, it had a scope. It was actually very narrow. That the special master is given an empty mandate. Who is she monitoring and evaluating? So on this notice of motion, it is unclear who she would be monitoring and evaluating.
The matter adjourned until Tuesday, when the state will respond, and the DA is set to make arguments as to why it sought the court to set aside Eskom's tariff hikes. For Newzroom Afrika on Channel 405, I'm Juniour Khumalo at the Pretoria High Court.